Hi, everyone. Carl Steinbeck. Good evening. Want to continue on tonight to part 2 of what we started last night, which was a playing of the testimony of Sergeant/Detective Brian Albert of the Boston Police Department in the case of Massachusetts versus Karen Reed, a murder case where she's accused of second-degree murder, along with a couple other charges involving the death of Officer John O'Keefe, a boyfriend of hers. So what I want to do tonight is just continue on where we left off. Keep in mind this Brian Albert was at the time a 30-year sergeant with the police department of Boston. And so he retired shortly after this. So we're going through his testimony and we're seeing what clues are there that he's not being forthright and honest. And it's very telling going through this that there's some other issues going on because there's so many times he's not giving a straight answer we saw from last night. So let's see how the rest of this works out. And don't know if we'll have a part 3, how much we'll get through tonight, but let's go ahead and get started.
Period. So I was just making sure that the dog was all right with the people that were over, end quote, correct?
Yes.
So in fact, you did keep Chloe downstairs at least for a period of time.
Technical problem, stand by here. Let me see, it's supposed to be adding on here. Sharing a screen. Trying to have this as a prominent display, but it's only doing a solo layout, so I don't know what's going on here. All right, hold on. Let me start over again. Stand by, please. Don't know what's going on, but I'll hopefully figure it out. Okay, here we go. I'm getting to his testimony again. I think I'm getting it. Okay. A lot of buttons to press, a lot of technical stuff to have to jump through here with the StreamYard process. So here we go. I think we're ready now.
That were over, right?
Yes, for a few minutes, I think.
Mr. Albert, after you learned that there were questions being raised about John's injuries and dog bites and scratches, in May of 2022, you got rid of that dog. No.
Objection.
Sustained. You can ask it differently.
At some point,
Why would there be an objection by Lally on this? It makes no sense. He's just trying to stop cold anything the defense is trying to present. It's just such a miscarriage of justice. If I was a supervisor of a prosecutor like this, I would chew him out like you could not believe. First of all, I'd be train him so he wouldn't be doing something like this. I'd train him up on the Sixth Amendment. I'd explain case law to him. So anyway, that's what we saw a lot of last night. It's just rampant throughout this trial. It's just so sad to see this kind of obstruction of testimony coming out that's totally legitimate. And then when you have a judge that seems to be in the back pocket of the prosecution, it's also very, very disturbing.
your family got rid of Chloe.
Chloe was rehomed in May
And we can use
2024.
whatever words we want to. Rehomed, rehoused, whatever. But you got rid of her. She's no longer part of the Albert family, right?
Objection.
Why is there an objection on this? This is totally legitimate, trying to get rid of a dog. The dog has something to do with the scene because the defense wants to bring out the fact that where was the dog in all this? Is a German Shepherd or German Shepherd mix. They'd be barking a lot. And so it does show that there's something hokey going on there at the Brian Albert house. And so that's why the prosecution wants to keep this out. So he's willing to waste time and do these objections and try to like throw off the defense. Why? Why? Because they know it's relevant. They know it sheds light on what's really going on.
Allow that.
Right.
When did you get rid of her?
So Chloe was rehomed in, I believe, May
Of 2022,
of 2022.
just months after the incident.
I understand this dog that they've had for like 6 years. So why was it suddenly rehomed? I did hear that the dog supposedly bit somebody after the death of John O'Keefe from the standpoint in May when they got rid of the dog. But if the dog really bit someone, then why was the dog put down? That's what's normally done in any city in America. If the dog bites somebody, they automatically euthanize it.
Discussing.
Well, after it was involved, she was involved in a dog fight with another dog out front.
Right, but that's also after the incident.
Yes.
we're discussing.
Yes, May.
Okay, well, if it's just a dog fight, what's so big about a dog fighting another dog, right? And they have a big, huge backyard. If you Google this address, you'll see what a huge fenced in yard it is. And so why was the dog outside in the front yard when you have that huge backyard? If it's out in the front yard, they have leash laws in Canton. So is he admitting that he broke the law on the leash law requirements?
That's a family pet that you had for 6 years or 7 years.
Approximately 6 or 7 years. Not
Your
sure.
explanation just now for having gotten rid of that dog is because it bit another dog and ultimately sent 2 women to the hospital, correct?
I believe 2 women went to the hospital. Yes.
Okay, so if that's after the case. That shows you how aggressive this dog is, right? So the dog is that aggressive and can easily be provoked. Yet, where was the dog the night in question?
But you took no action to get rid of Chloe until after you knew that serious questions were being raised about John O'Keefe's,
Objection.
correct?
Sustain.
This is so legitimate line of questioning. It's once again, you're not going to get a fair trial in this courtroom up there.
At some point, you did realize there were questions being raised about John O'Keefe's injuries on his arm, correct?
Objection.
I'll allow that. Did you realize that?
I heard some talk about it. Yes.
As of January of 2022, John O'Keefe had never been in your house, had he?
John O'Keefe was never in my house before or after that date.
Certainly, John O'Keefe, you would agree with me, he would count, were he in your house, he would count as a stranger to Chloe. Never met her.
Hypothetically, yes.
I want to ask you a couple of questions about your house.
Well, why would he say hypothetically? Either was a stranger or he wasn't.
Where are, I know there's multiple bedrooms. Are all the bedrooms on the top floor?
Yes.
Okay. How many bedrooms?
5.
As we're looking at your house from the street, looking at your house, are your bedroom windows, your and Nicole's bedroom windows, visible from the street?
Yes.
Which windows would they be?
If you were facing the house, they would be far left corner.
Upper or lower?
Upper.
Upper left corner.
Yes.
How many windows? 3 or 2 service that bedroom?
2.
Your Honor, with the court's permission, could I display Exhibit 66?
Okay.
Do you see what is displayed on that television?
Yes.
What does that appear to be to you?
The house at 34 Fairview Road.
Okay. Understanding this is a graphic representation, not a photograph. Do you see the windows that you just described servicing your bedroom on that graphic?
Yes.
Are they there?
Yes.
Okay, upper left, 2 windows, correct?
Yes.
And those overlook what part of the lawn?
The front lawn.
Okay, front lawn toward the left side of the house, not toward the driveway, correct?
Right. I mean, it's the whole front lawn, but yeah.
Right, but they're toward the left side of the house.
The windows are, yes. Are they asked about the view?
Right,
So the view's the whole front yard.
I'm just trying to make the record, the spoken record as clear as possible.
Right.
They're on the left side of the house.
Yes.
They overlook directly over.
Keep in mind, there's no deposition. So a lot of these questions, instead of a normal cross-examination, being controlled format where the defense counsel already knows the answer, a lot of this stuff, he's having to do it on the fly because he doesn't have prior statements for this witness because there was no depositions allowed in Massachusetts. So
Overlook. They directly overlook this portion of the lawn, the left side of the lawn,
Yes.
furthest from the driveway.
Yes.
We can take that down. Where's your bed, or where was your bed inside that room as relates to the windows?
I'm just trying to think of how to describe it. So the bed would be in the middle of the bedroom.
Okay, it's a bad question on my part because we haven't been there. Let's do it this way. How many feet from the windows would the closest part of your bed be to those windows?
Maybe 5 feet. 6 feet.
You indicated that Nicole came to bed about 2 o'clock in the morning.
Yes.
Where was the dog?
The dog was in my room.
And she was sleeping on a mat in your room.
Yes.
And that mat is also about 6 feet from the windows.
Yes.
6 feet being from me to Miss Little. Maybe this far?
Could be, yes. Maybe a little further, but yes.
Maybe this far?
Maybe.
It's a relatively quiet street generally, Fairview.
Yes.
Not an enormous amount of through traffic,
No.
not a busy freeway or a highway, correct?
No.
Not an especially noisy street,
The street, no.
especially at 6 a.m. on a Saturday morning, right?
Right.
Where were you at 6:03 on the morning of January 29th, 2022?
I was sleeping in my room.
6 feet from that window.
Yes.
Was Nicole in bed with you?
Yes.
Had you taken any medication the night before?
No.
Were you on any sedatives,
No.
sleeping pills?
No.
Were you wearing a sleep apnea machine? Were
No.
you wearing an eye mask?
No.
Were you wearing earplugs?
No.
You shortly thereafter became aware that 6 emergency vehicles, including a fire engine, police cruisers, and unmarked police vehicles, a civilian SUV, were all parked in front of your house that morning, correct?
I'm not aware of what type of vehicles were parked there, no.
You seen photographs?
So he doesn't even know what type of vehicles were out there. Even all the time that they were out there, he never knew what was going on. Of course, he would know as a police detective what type of vehicles be out there. So he just slept through this whole thing. It's just really bizarre. It's just not credible.
Since this incident?
Of the vehicles out front?
Right.
No.
Are you aware that all of those vehicles had their engines running?
No.
Are you aware that all the emergency vehicles at least had their lights on, flashing lights?
No.
Were you aware that there were first responders outside their vehicles traipsing around your lawn?
Was I?
I mean, he's basically in a comatose state. There's a dead officer right out in his front yard. An officer that he knows that he had drinks with a few hours before that. And he's not even concerned about it. He doesn't even go out there even after he's awakened by Jen. So we'll get to that. But keep in mind also how this contrasts with him having gone the morning prior down to New York City to attend a memorial service for a police officer he likely didn't even know.
Where?
Were you aware at the time?
No.
Were you aware that there were emergency responders, first responders, who were talking to each other over the din of the wind and the snow?
What?
To communicate with each other?
No.
You're aware that there were 3 women on your lawn at one point?
Just only after the fact.
And at least one of those women?
So all this happened. They hauled John away by ambulance. all this commotion going on. He just completely slept through it, right? It just so far-fetched, incredible.
Woman was screaming to the top of her lungs at 6 a.m.?
No.
Screaming going outside upon finding John. I mean, it's just, how can anybody believe this?
Again, your German Shepherd was 6 feet from the window, correct?
I don't know that for sure.
That's where Matt was.
Well, that doesn't mean that's where she always is. She also sleeps in the closet area sometimes.
Oh, so now Chloe's in the closet.
I didn't say she was in the closet. I said she sleeps in the closet area sometimes.
Was she sleeping in the closet area that morning?
I don't remember.
Likelihood is she's sleeping on that mat 5 or 6 feet from that window, correct?
Judge, I don't know.
And your
The dog alone enough to show that he would wake up, even if he was a heavy sleeper, didn't wake up easily. Dogs like that, a German Shepherd, especially somebody that wound up biting somebody or some gals after the fact, after they rehomed it, is surely going to make such a commotion, barking, yipping, just gangbusters wanting to get outside. Would have probably gone to him as the owner and said, "Get me out of here, get me out of here. I got to go see what's going on outside. Pay attention." And him as a 30-year veteran of the Boston Police Department, he knows something's going on in his front yard. There's no way that's credible for him to deny it.
explanation, and by the way, we've already talked about this. Earlier that day, you've already indicated she was barking because she heard people and noises downstairs when you guys came in the house.
Yes.
And your explanation is that you and Nicole and Chloe, the German Shepherd, all slept through the entirety of that commotion on your front lawn.
Yes.
To be clear, you are a trained first responder.
Yes.
Yet during that entire event, after you were awakened, all that chaos on your front lawn, you never came out of your house to assist or investigate in any manner whatsoever, did you, Mr. Albert?
Once I was awakened?
Correct.
No.
We've talked about this a little bit, but I want to.
Unbelievable. There's no way a normal police officer with any years of experience would just sit there and let this happen in his front yard and not do anything to inquire or ask to assist. And so what is there going on here really behind the scenes that this would happen? And he's just basically checked out even after he's woken up.
I ask you a couple of other questions about the layout of the house. The house is sitting on top of a basement, correct?
Yes.
Or was at the time. Describe how you get to the basement from inside the house if you come in the front door. And when I say, I'm sorry to do this, I don't mean to interrupt you. There's 2 front doors that you go in, correct?
Yes.
For purposes of my question, Mr. Albert, I'm going to talk about the one that's right in front of you, the obvious one, as the front door, and the one to the right of it as you're looking at the house as the side door. Okay?
Okay.
Because I don't know how else to describe it. If you come in the front door, describe for the jurors, where is the basement door as compared to that?
So you walk straight ahead. You pass the kitchen dining room area opening on your right-hand side. And there's a door on the left.
How many paces? The door opens. How many paces to walk over and grab that door handle?
I'm not sure, maybe 10?
10 full paces.
Maybe, yeah.
So
Maybe 8, maybe 8.
Albert, it's about 4 long steps, correct?
Well, I don't know. You asked paces, so, 6 feet.
I mean, correct me if I'm wrong, but to this day, that house has never been searched. Never been searched. I mean, this is such a gaping hole in normal police procedure. These people in the house would automatically be people that are questioned, that all had to be ruled out as suspects. John was invited to the house. Him and Karen were invited to the house, moving from the bar that they were attending earlier to go to this house. So everybody in that house should be questioned. They should be brought down to the police station. If they're going to be interviewed at the house, it should be very brief just to bring them further on down to the police station. And then you have follow-up interviews that are fully in depth. So this thing was never processed as a murder scene at all. It's more like he just had some kind of a heart attack or something, like some kind of medical thing happened to him, because it surely was never processed as a murder scene.
6 feet.
6 to 8 feet, maybe.
Got it. What was the basement used for in January of 2022?
So the basement had a weight room in one of the rooms, and the other room was nothing at the time. It had been damaged, water damage due to an overflowed toilet.
So part of the flooring had been ripped up,
Yes,
and that opened up some slab concrete downstairs.
yes,
There was also some plywood downstairs.
yes,
There were a couple of mats where the actual weights were, so they're not slamming down onto concrete.
yes,
But there was a good amount of that floor that was just exposed concrete.
yes,
The workout equipment would include things like, what, barbells, dumbbells,
yes,
heavy weights,
yes,
heavy bars,
Yep.
made from metal.
yep.
Once you're down in the basement, by the way, there's 2 flights that you go down at angles to get to the basement. A series of steps, a landing, take a left, another series of steps, and you stand on the basement.
Yes, not a long staircase, very small, but
Right. I mean, it's narrow and tight, but in other words, you don't just walk straight down a staircase. You go down to a landing, turn left,
turns a little.
go down, turn left again, and now you're in the basement.
Yes.
If you wanted to move something large or heavy out of that basement without having to go through the house, could you do that?
Objection.
I'll allow it.
Could you rephrase the question?
I'll say it again. If you wanted to move something large or heavy out of that basement without having to go through the main house, could you do that?
Yes, I mean, it would depend what it was, obviously, how big it was, or
How would you do that?
there's a bulkhead door you can use.
Got it. Where does that bulkhead door come out of?
It comes out to the backyard right at the kitchen area. You can see it from the kitchen.
And right to the,
For those of you not familiar with it, bulkhead doors are those kind of like doors that open up like this. They're laying almost flat on the ground, and they have steps that go down into a basement area. So you only see that up in the northern part of the United States, where they have basements for the most part. In the southern part of the United States, basements are really rare. So that's what he's talking about there. And it's a way to bring in larger objects in through the basement and out of the basement. So things like refrigerators, whatnot, is how you go through there, rather than going through the main part of the house, then going from the interior steps down.
the left of that is the side fence.
Yes,
And directly through that side fence is the front yard.
yes,
The same side of the front yard as John O'Keefe's body was found.
yes.
Your Honor, I would ask at this point to mark a video. I'm gonna have just a moment. Yes.
Mr. Jackson, would you like to take the morning recess?
That'd be great. Good time. Yes, thank you.
Court, all right, please.
All right, are we all squared away?
Yeah,
Okay.
thank you. Mr. Albert, did you speak with anybody at the break? about the testimony?
Just my attorney.
May I approach?
Yes.
Okay, now he admits that he spoke to his attorney. That's something I would have brought out in the very beginning, that he's had this attorney on retainer. I asked him how much he's been paying him, how much he pays an hour. And is he with him every part of the way when he's going to the grand juries? Is he outside the grand jury room? Go into all this kind of detail because a law enforcement officer that had a murder happen in his front yard and he's not doing anything to take part in assisting or seeing what's going on once the 911 calls are made. So why is he having a lawyer, right? So he should know that the law enforcement folks that he's been working with for 30 years aren't going to be out to get him. They're not going to set him up. Does he really think that the folks there are that corrupt that they would try to frame an innocent cop? So why does he have a lawyer?
Mr. Albert, if you could please tell me if you recognize what's depicted in that photograph.
Yes, it's the bulkhead stairway.
Is that the stairway that you earlier described for the jurors as servicing the basement going into the backyard?
Yes.
Their approach?
Yes.
I would have asked to have this marked as next in order.
Okay, any objection?
Exhibit 16.
Thank you.
Ma'am,
Yes.
move to publish, Your Honor.
Okay.
Do you see what's depicted on the television screen?
Yes,
Does that appear to be the same as what you're holding right there, that exhibit?
it does. Yes.
Okay, I'm going to direct your attention, if I could, to the lower left portion of this photograph. And right there. Do you see that? Tell me what that is.
I can't.
Let me highlight it one more time, right there. Maybe it's easier if you look on your photograph.
Are you referring to the doorknob? Yeah, I got it here. Yes.
Okay, I'm sorry, it's sort of hidden on that photograph, so I apologize. Is that the door that swings open or closed to close off the basement?
Yes.
Then if you open that door, it's in the open position now, correct?
Yes.
So the photographer is standing in the basement looking toward the doorway, correct?
Yes.
Then you climb 7 or 8 stairs,
Yes.
and that bulkhead door, which is where all the light is emanating, how does that open?
So the bulkhead door opens straight up.
Okay, at least in that photograph, it was hinged toward the house and it would open up like a sandwich or something.
It opens straight up to the bay windows that are in the kitchen.
Got it, okay. Okay, that's all I need for that photograph. Your Honor, I have a flash drive with a video on it. I'd ask that this be marked as next in order. Court's permission.
Assuming it's the same one, no objection.
It's the same one.
Exhibit 69.
Mr. Albert, I want to ask you to take a look in just a second at a video and then describe if you recognize what's in that video. I'll probably play maybe 5 or 10 seconds of it and then pause it. If that's okay.
Okay.
Court permission?
Yes.
Right, that's the outside of it. You pull the lever. There's the
Pause.
stairs, and there's the door.
Do you recognize what's depicted in that video, at least up to that point?
No.
Does that look like your basement door, although the bulkhead doors have been replaced different?
The whole thing looks different to me.
Let's go and play the video. Pause. Now do you recognize what's depicted in the video?
Yes.
What is that?
So that's was my backyard.
Okay. And what area is over to the left over here?
That's a gate.
Okay.
So why would the dog be out in the front yard attacking another dog? And that's why they get rid of it, right? That's what dogs do is they fight. That's normal for them to do. So if the dog was outside and they've had it for 6 or 7 years, why would they get rid of the dog? It makes no sense. In this question, I I would say as a follow-up as well, what did you speak to your lawyer about? So all that is permissible questioning of this witness. It's the state's witness. He's not the defendant. So anything he's done with attorneys, it's fair questioning. So yeah, that's something that should have been followed up on.
And what does that gate open up to?
To the front yard.
So the area that we're looking at right now, where the photographer is standing, is the backyard.
Yes.
Now, having seen that, notwithstanding the way that the bulkhead doors open, now do you recognize what was depicted at the beginning of the video, which was that staircase?
Yes. The downstairs door, the door itself, the wooden door itself also looks different.
Okay, so, but it is
But it is the stairway. Yes.
going into the basement?
Yes.
Or coming out of the basement?
Yes.
So in other words, another way to put that is that represented the ingress and egress through the bulkhead to the basement.
Yes.
Okay, let's go ahead and play this.
Look how big that yard is. 0.778.
Did you recognize what was depicted in the video? Bring the lights up. Thank you. Thank you, Your Honor. Did you recognize what was depicted in the video as it continued to play?
Yes.
Describe that for the jurors, please.
Looked like the video was from walking from the backyard towards the front yard.
So the video started at the bulkhead door, turned toward the fence, went through the fence, and right up toward the flagpole, correct?
Yes.
Is that an accurate representation of the layout of the house when you lived there on January 29th, 2022?
Yes.
With the exception of the bulkhead door having been replaced and maybe the basement door.
Yes.
By the way, the 34 Fairview house had been in your family at that time in 2022 for 2 generations?
My parents built the house in the late 70s, 79 maybe.
So if your parents are 1 generation, you and your family are another generation, 2 generations.
Right.
Nearly, maybe actually a little more than 50 years, half a century.
That what?
It was the Albert home.
Yes.
The fact is, you listed that house for sale for the first time ever in November of 2022, correct?
That's the time we listed it. Yes.
Just months after John O'Keefe was found on your lawn.
Objection.
Stain?
Mr. Albert, is that timing, according to you, a coincidence?
Is what?
Is that timing a coincidence?
See, is what he knows exactly what the question was. He's buying time. He's hoping the prosecution is going to object. He's leaning forward a little bit, so that could be also another signal to Lally, hey, object.
Well, that's not the timing. Actually, we contacted the realtor in 2021, finally listed it in 2022.
Got it.
So that would be pre-incident.
So the listing coming 9 months after John O'Keefe was found dead in your lawn, dying in your lawn, that's just coincidence. You had this in place long before that.
Objection.
So I'll sustain the question. You can ask it differently.
Sure.
What's wrong with that form? This makes no sense. All right. It was perfectly legitimate.
All I'm asking is the timing, November of 2022, listing that house for sale for the first time in November, that in your mind is just a coincidence.
It's not a coincidence because we started trying to look into selling the house in 2021, which was the few months prior to the incident.
On January 28th, 2022, you were still an active Boston police officer, correct?
Yes.
What was your job title in January 2022?
Sergeant Detective.
That means you not only respond to incidents, you actually conduct investigations as a detective, correct?
Yes, primarily fugitive investigations.
You have additional training in order to hold the title and hold a position as a detective. Is that right?
Yes,
Not just a regular patrol officer. You have to have special training to get to the rank of detective. Is that right?
yes,
As a sergeant detective, that's above a regular detective, indeed, because you're a supervising detective. Is that right?
yes,
You have experience in training in order to hold that position as a supervisor in the detective spot as well.
yes. There's civil service tests for the rank, but yes,
And you've investigated crimes. I mean, I'm guessing just a ton of different types of crimes, including assaults, manslaughters, homicides, kidnappings, things of that nature.
no,
You've never investigated anything like that.
no.
So what's the parameters of your investigative skills as you held that title of sergeant detective?
So my parameters were investigating fugitive investigations. That was my specialty, I guess you could say.
So you've responded to, obviously, to countless incidents and scenes as both a patrol officer
Yes,
as well as a detective.
yes,
You've supervised the investigation of at least the fugitive type of crimes, correct?
yes,
Fugitives trying to thwart investigators to try to find them, right?
yes,
That's their whole, it's the cat and mouse thing, right?
right.
You being the cat, correct?
Sometimes,
Find the
some,
mouse.
yes,
You're also trained in techniques, obviously any detective would be trained in techniques that
Right,
culprits
right.
might use or suspects might use to
Thanks for
sort
alerting
of
me.
cover up investigations. I'm sorry, to cover up crimes, to thwart investigations, correct?
Objection.
Do you have that training, sir?
no,
So you, in all of your training, 30 years as a Boston police officer, and as a sergeant detective, you don't have any training in what techniques criminals might use to try to cover up their conduct?
no. I've never gone to a training for criminals to cover up conduct, no.
Never been trained in the fact that, I don't know, somebody might want to clean up blood at a scene.
No,
Objection.
Would be interesting.
What about sanitizing a location?
Objection.
I'll allow it.
no,
What about getting rid of electronic data? You've got to have training in that.
no,
In other words, the fugitives that you chase down and try to find, you don't try to utilize electronic data to go after them?
sometimes we do, but I don't have any training in it per se.
I mean, things like GPS data and phone calls, and text messages, communications, things of that nature, obviously.
Yes, yes,
Clearly. These are all things that, at least those things, are things that if you didn't have formal training, you got on the job training and just have common sense about how to go after this type of evidence, correct?
yes,
Sir, you had an iPhone with a number ending in 0888 back in January of 2022, did you not?
yes.
How many years did you have that iPhone as of January 28th, 2022?
Of several years, I'm not sure how many, but multiple years.
And Mr. Albert, you were notified by the Commonwealth that on September 23rd, 2022, in the fall of 2022, a judge specifically ordered that you were to preserve that phone.
Objection, Your Honor.
Data, correct?
I'll see counsel at sidebar.
Notice that every time there's a major point defense should be making to be an effective defense lawyer. What's Delali doing? He's objecting. This is just so disappointing. He's not the only one that does it in the cases I've seen, but this is the most blatant version of it. And it just leads me to believe that, it's win at all cost type mentality. It's not about justice and fairness. And if you really have somebody guilty, you don't have to resort to this kind of blocking of defense questioning and defense evidence. But that's what you do when you have a loser case and you're trying to prop it up and you're trying to limit the information that the jury can get before them. And for him to say he has no training, understanding of this kind of stuff, he doesn't actually do it himself. The question is whether he's had training of it, whether he has knowledge of it. He's not asking whether he's actually been the one to do that. So he's again playing semantics. He's trying to bob and weave. So it just doesn't come across as credible testimony again.
Thank you, may be seated.
All right, and I am going to see if his counsel here, he has a right to be present in the
Okay.
courtroom.
May I step up for a moment, Your Honor?
Sure. All right, so Mr. Jackson, you can have a voir dire.
Albert, you're currently represented by Mr. Higgins.
Yes.
Seated behind.
Okay, so this would be, it looks like they took a break and the jury stepped out. So when they do voir dire, that's, unless you're doing that for the jury, normally if you're doing it for any kind of witness, the jurors would not be there.
Gentleman in the,
Yes.
in the gray suit. Correct?
Yes.
Okay. Without telling me anything,
This is something I said yesterday you should have brought out is, hey, point out your lawyer. The first thing you would have asked them is, where's your lawyer in the courtroom? And I think that really helps get people's attention on the jury. It's like, hey, wait a minute. So this is a 30-year cop and he's coming on there and has his own personal lawyer. It's just really bizarre. What's he got to hide?
you've ever communicated with him. When did you hire him as your lawyer?
I'm not exactly sure of the date.
Give me a time frame. Let's see if you can narrow it down.
2022. I'm just not sure the exact date or even the month.
For the end of 2022?
I'm not sure. I believe prior to some of the other testimony that I gave. So prior to
April of 2022 at the state grand jury?
No, prior to the other testimony.
Okay, that was in June of 2023. That's my question. Did you hire Mr. Henning in 2023 in anticipation of giving testimony in June of 2023?
I'm not sure of the exact date. I believe it was maybe the end of 22. I'm not sure.
Or did you get a subpoena for the other hearing?
I did.
Okay. Did you hire Mr. Henning after you got that subpoena?
I can't say. I believe so. Right around that time. Yes. I'm just trying to remember the time, and I can't remember it.
So you did not hire, well, Your Honor, I think that answers the question. Not represented in 20.
I'm going to see at sidebar about the extent of the inquiry.
Thank you.
May I interrupt?
Yes.
Thank you. You had received, and I want to draw your attention to 2023 now. I'm sorry. Now I'm doing it.
Just one thing about this, though, is that under Massachusetts criminal rules of procedure, the requirement is just to state an objection. They don't have to state the basis for it. It's really weird. You don't have to state the basis for it. You may state the basis for it, but you're not required to. And then the judge will make a ruling on it. The non-movement of the objection can make a premise for why they want to admit that evidence. But what happens is the judge makes a ruling before the defense can ever say anything. So what I would do is, as soon as I hear an objection, I would state the basis for why it should be admissible, because the judge is not asking the basis for the objection. And I guess for some reason under the rules, they don't have to there. I know under federal rules of civil and criminal procedure, that's not required as well. In the olden days, you had to state the basis for the objection. Otherwise, it would be waived for appellate purposes. So they've relaxed those rules a lot, and they don't want to have, I guess, so much time during the trial processions to have the legal foundations for why you're objecting. And so to me, I think it's really, this gives a way for attorneys to be lazy and obstructionists, to just basically try to hamstring the whole trial process by just continually objecting. And you don't have to know the basis of your objecting, and the judge is supposed to figure it out. And the other side, if they're not going to try to counter that and give the basis for it, what I've done many times is, if a judge doesn't rule the correct way, I keep arguing it. And I'll go up there, ask for a sidebar. I'll explain to the judge why it's relevant. So if a judge is going to give a rapid response, sustaining of the objection of my opposing counsel, then I'm going to keep going after that and following up and not just take the first thing that the judge rules on. I'll ask her to reconsider or him to reconsider. So that's never been done here by Jackson. So that's what I do to push back when you have this kind of one-sided justice going on.
The fall of 2022, September of 2022.
Yes.
Did you receive a notice on Commonwealth letterhead indicating that you were not to destroy or in any way manipulate any data on your cell phone, destroy the phone itself, or to manipulate or destroy any data on that cell phone?
I do not remember getting that letter. No.
I'm going to read this for the record, Your Honor.
Yeah, so we have it on here, the New York patrol officer retired. Thank you for joining on and having a vested interest in this case. You've also said how outrageous this case is. Nothing was done to standard. I know you've said that the way they failed to preserve the so-called crime scene and didn't section it off, cordon it off. They didn't put any tents up. They didn't put any heaters out there to melt the snow to see what was left behind. So yeah, this is completely botched. You couldn't ask for a worse type of investigation. And then the way Proctor handled himself, I mean, this is like textbook of how you don't handle a criminal investigation on a case, on any kind of case, let alone a murder case.
If I may, with court's permission.
Yes.
Did you receive a letter that said, in essence, not even in essence, it should be quoted as the following, quote, "You, Mr. Albert, are hereby notified that the defense in the case of Commonwealth versus Kieran Reed, Norfolk Superior Court, criminal case number 22-117, has filed a motion pursuant to Mass R. Crim P. 17 for the production of any cell phones that you used between January 28, 2022 and February 28, 2022, and or any data associated with those cell phones, period. The hearing on Ms. Reed's motion will be held on October 3, 2022 at 2 p.m. in courtroom 1 of the Norfolk Superior Court. You may be heard on the motion at that time."
I just want to say this screen here says voir dire, but I think the voir dire has already ended. I don't believe that they'd be doing these kind of questions without the jury back in the room.
You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of these electronic data associated with the cell phones at issue. Period, end quote. Did you receive a notice from the Commonwealth with that language?
I don't remember receiving that document, no.
Were you told in any other capacity that you were not to get rid of or delete your cell phone? In other words, preserve your phone.
Subsequent to me upgrading my phone, I spoke with the DA's office. So after that, they told me via a phone call that that was the case.
So your testimony is you never received the notice that I just read, but you did talk to the DA and he told you to preserve, you were on notice that you were to preserve your phone.
After.
I know
Right,
you
well-
want to say that, Mr. Albert. My question is, did you have the conversation with Mr. Lauer?
Yes.
Okay. When was that conversation, sir?
So I don't have the exact date of the conversation. I'm not sure.
Who did you talk to on the phone exactly? Was it Mr. Lally alone or was it a conference call?
It was a conference call.
Who else was on that conference call?
I believe Steve Nelson and other witnesses in the case were on the conference call.
Can you name those witnesses for us, please?
I believe it was Brian Higgins. I believe.
That's so wrong. You always interview witnesses individually. Even the New Jersey retired officer said you section people off, you cordon them off, you make sure you have each witness saying their own testimony. You don't want them listening to other witnesses' testimony because that can make them try to get in lockstep and alignment with each other. You want independent scrutiny and independent question with any particular witness of any type of crime. So having them as in a group at any point, even whether it's initial interview or subsequent interview, to part of trial prep, you never commingle the witnesses together and talk about the evidence with them in earshot of each other.
Jen McCabe, Matt McCabe, and maybe somebody else, but I can't recall.
Who initiated that conference call?
I believe it was somebody in the DA's office, so either Mr. Lally or Steve Nelson, somebody like that.
Did everybody just call into a central number, a conference line?
Yes.
And what exactly did Mr. Lally say to you during the course of that conversation about preserving your phone?
During the conversation, Mr. Lally said that the defense had filed a motion to ask for the phones to be preserved.
And anything else?
That's what I remember him saying.
Did you volunteer that, oh my goodness, I just upgraded my phone last week, convenient. I don't have that phone anymore.
No.
You didn't say that to Mr. Lally?
No.
You just took the information that he gave you and hung up the phone and what about your business?
Yes.
Without notifying him that the very phone that he had just ordered you to preserve had just been destroyed days earlier.
No, the phone wasn't destroyed. I upgraded the phone.
The data was destroyed, sir. Correct?
I did not destroy any data on any phone.
Mr. Albert,
I upgraded my phone.
when you upgrade a phone, you know that the phone is set back to factory reset before your new phone is handed to you, correct? Happens every time.
I don't know that.
So if you have personal texts with your doctor, personal communications with Mr. Henning, your lawyer, you're just gonna hand that to a pimply-faced kid at Best Buy and say, here's my phone? You know that data is destroyed when you upgrade your phone, right?
I think some things are come over across contacts, things like that. So I don't know that for sure.
You can back up your data, sir, but the phone data is destroyed for all purposes. It's factory reset, correct?
I don't know that.
How long do you have a phone? That's an iPhone.
Years.
How many times have you upgraded your iPhone?
Multiple times.
Every single time you upgrade it, you know that the phone prior, the data is destroyed on it, correct?
Usually my contacts come over and my photos come over. So
That's a backup.
no, I don't think I have that on backup, but okay.
Irrespective, you didn't tell Mr. Lally that you had gotten rid of that phone.
I was not asked that and I didn't tell him that.
I see. You felt like if you weren't asked that, you didn't need to volunteer it, even though the conference call was specifically about preserving your phone pursuant to a judge's order. Correct?
What was the question?
You didn't offer to Mr. Lally that you had gotten rid of the very phone that he was telling you had to be preserved due to a judge's order.
I did not.
And you didn't seek any advice from, I'm not asking you for the communications. You did not seek any advice from counsel at that time for those purposes.
I don't believe I did. No.
They have just told me.
Sure.
Keep in mind, he's got connections with the law enforcement there at Canton. His brother works there. He got inside information on he needed to get rid of his phone, and that's exactly what happened. It just seems too coincidental for him to get rid of his phone. Keep in mind, there's also these other issues of where we have the ATF agent Higgins also getting rid of his phone. So there's just so much suspicious activity here going on. It's you ask yourself, why would all this suspicious stuff be going on if Karen Reed was guilty of this and they knew they had her dead to rights?
At some point, you indicated, Mr. Albert, at another proceeding, under oath, in relation to a conversation that you had with Brian Higgins about your phone. Quote, I don't recall saying I was going to get rid of my personal phone to Brian Higgins. I may have said that, there's personal stuff on my phone. But I don't recall saying that to him, but I don't know. We had multiple conversations about things. Remember saying that under oath at another hearing?
Yes.
You literally admitted at that hearing there's personal private data on that phone. Hence, you got rid of it, right?
No,
You certainly wouldn't allow some kid at the AT&T store to have your personal private data. You're a cop.
no, I assume he doesn't have it
Why would you assume that?
because he took the phone and has it.
And what do you think happens to the data on the phone, sir? Let's just use common sense. What do you honestly think happens to the data on the phone when you turn it in and upgrade your phone?
I'm sure that the data's not there anymore. I'm sure.
It's destroyed, sir, correct?
I don't know that for a fact. I know that.
Oh, come on. Really? They're going to keep the information on there. It gets erased. They erase the hard drive. So that's sort of a common sense type of thing. So I just don't find that credible.
Some things are transferred back to the new phone.
You just said, the data is not there.
Some data, I guess, isn't. Yes.
No, that's all I have.
All right, Mr. Lally, any questions?
No, Your Honor.
All right, I'm going to take a short recess. All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Mr. Albert, you were notified by the Commonwealth that on September 23rd, 2022, a judge specifically ordered you to preserve that phone and all its data, the phone ending in 0888. Is that right?
Yeah, at what time are you asking me that I was notified?
That day or the next?
On the 23rd?
On the 23rd or the 24th of September?
No.
Isn't it true that you were provided a letter by the Commonwealth that stated the following? Your Honor, if I may read this.
Yes, there's no objection.
Thank you. Quote, you are hereby notified that the defense in the case of Commonwealth versus Karen Reed, Norfolk Superior Court criminal case number 22-117 has filed a motion pursuant to Mass R Crim P 17 for the production of any cell phones that you used between January 28, 2022 and February 28, 2022, and or any data associated with those cell phones. The hearing on Ms. Reed's motion will be held on October 3rd, 2022 at 2 p.m. in courtroom 1 of the Norfolk Superior Court. You may be heard on the motion at that time. You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of the electronic data associated with the cell phone at issue. You received, end quote, you received that notice on either the 23rd or the 24th. Is that right?
I did not.
Honor, I would pose a stipulation. I spoke.
So why wouldn't he get that kind of notice? If he's saying he never got the notice, keep in mind also him being a 30-year veteran, he knows that he should be looked at and he should be a suspect in this case. And so that alone would be a reason. He doesn't want to get rid of his phone because he wants to preserve everything, show that he doesn't have anything to hide because it makes him look suspicious. So what does he do? He gets rid of the phone. And so here's a good point here. You purchase new phones and all the data, contacts, and apps are all transferred to the new phone. Well, if his phone's never been reviewed by law enforcement, then maybe that's still a possibility. But so I don't know how much of that would actually be transferred or not. And so in any event, getting rid of phone definitely throws that into question. So maybe some of it's erased or all of it's erased. But either way, it definitely is something that to the average person looks very suspicious.
With counsel off the record, if I may.
You both have a stipulation that I haven't seen.
We just determined I'm happy to approach it.
Why don't we approach quickly?
Yeah, again, North Carolina retired officer, you're saying it's hard to believe. Yeah, the whole way this thing has gone down, it's really disrespectful to Officer John O'Keefe and his family that this was never treated as a crime
Yes, I would offer the following stipulation that on either September 23rd or September 24th, the Commonwealth sent a letter on Commonwealth letterhead to Mr. Albert's attention, stating exactly what was just read into the record pursuant to the court order dated September 23rd, 2022.
Okay. All right, next question.
Thank you, Your Honor. Isn't it true that you were in fact ordered to preserve your cell phone by the Commonwealth?
At some point, I was made aware of that, yes.
All right, let's just get to the brass tacks. Where's your phone?
My phone was upgraded and traded in for a new phone.
Your phone was upgraded and traded in for a new phone.
Yes,
Another way to say that is you traded your phone in and got rid of it, correct?
I traded my phone and upgraded it. Yes.
When did you get rid of your phone ending in 0888?
I upgraded my phone in September, third week of September, maybe around 22nd.
The 22nd of September.
I believe so. I can't be sure the exact date.
So according to you, you got rid of the phone that was the subject of a court order preservation the day before it was ordered preserved, right?
Rephrase the question, please?
This order was just stipulated, this order is dated September 23rd, 2022. It was just stipulated that on the 23rd or 24th, you were then sent a notice to preserve the phone. And your testimony is on the 22nd, the day before this all happened, you upgraded your phone and got rid of it in total, correct?
I upgraded my phone on and around the 22nd, yes.
And you knew that all of the data on that phone would be factory reset and destroyed.
Objection.
Do you know that, sir?
I do not know that.
How many times have you upgraded?
Of course, you're going to ask what is preserved, what's saved anytime you transfer a phone. For him not to say this, very, very good indicator that it's pretty much along the lines of the rest of his testimony.
Your phone in your iPhone.
I'm not sure. 4 or 5 times, maybe.
You're aware that when you turn a phone in and you upgrade it, the phone that you turn in, that data is factory reset, meaning it's gone. It's destroyed off of that device, correct?
Well, I think some data transfers and some doesn't.
We're not talking about a backup. I'm talking about the physical phone. That physical phone becomes a brick when you turn it in, correct?
Correct that it becomes a brick? I don't know.
It becomes effectively a brick. There is no data left on the phone. I'm not talking about backup data onto a cloud. I'm talking about that phone.
So the old phone, yes.
Yeah, it's just everything on it's destroyed, correct?
Right, although some of the data transfers to your new phone.
And you're aware that the very data that you were ordered to preserve would have been destroyed, according to you, the day before. Correct?
Rephrase your question or ask me a question.
Are you claiming that you got rid of your phone on the 22nd?
I upgraded my phone around that. I'm not sure if that's the exact date, but yes.
So it could have been after the 22nd.
I don't think it was after the 22nd.
Could have been the 24th?
No,
Could have been the 25th?
no.
So you're absolutely sure that you could not have upgraded your phone and gotten rid of it anytime after the 23rd when this judge ordered that it be preserved?
No.
Because you know that if you got rid of that phone after you had been notified that you were ordered by a court to preserve it, you'd be committing a felony.
Objection, Your Honor.
Sustained.
So you now.
Wow, this is again sham justice. It's not even any kind of resemblance of fairness, and it's just really sad to see and very disgusting. It's very, very much something that I would say is no doubt this is the worst prosecutor I've ever seen in terms of trying to derail a fair hearing, a fair trial for the defendant. So it doesn't really get any worse than this, folks.
I'll claim that you got rid of the phone on September 22nd, 2022. Hours before you were ordered to preserve it. That's your testimony, correct?
Yes.
Is that just a coincidence?
September 4th was my birthday. The phone was broken and failing. I had planned on getting a new phone, and that just happened to be the day that I got it.
Happy birthday. Was that a coincidence?
Objection.
Sustained.
How is that not a proper question? It's just a coincidence, and that's not even a very confrontational way to say you try to get rid of this phone because it had information on there you didn't want transferred over. You didn't want text messages transferred over. You didn't want other conversations and the timing of the texts and phone calls and that surrounding the death of John O'Keefe. That's really what he's could be asking, and so he's asking in a shorter version of that. And so for Lally to object to that, I just have zero respect for this process. This is really a sham. This whole court process here, very, very disgusting to see this.
You were asked at another hearing in June of 2023 that exact question, correct? Whether it was a coincidence. You remember that?
I don't.
You recall being asked, quote, so it's just a coincidence that within minutes, hours, or days.
Objection, Your Honor.
Let's hear the question first.
Within minutes, hours, or days of you trading in your phone, that phone you had in January of 2022, that you were ordered to preserve it. Answer, yes. Question, that's a coincidence? Answer, yes.
Objection. Move to strike.
I'll let that stand.
It's something I already said, Lally. This is totally permissible under the rules of evidence as impeachment type of cross-examination. So it's just very, very much out of line. It's not about getting a fair trial for the defendant. If you got a guilty party you're prosecuting, you can let this stuff in. It should be admitted. So just being a constant objectionist like this is just very, very disturbing to see.
That was your testimony, wasn't it?
Yes.
And that's what you're saying today to these jurors. Just
Yeah.
a coincidence.
Yes.
Did you and Brian Higgins agree with each other that you were both going to get rid of your phones?
Objection.
I'll allow that.
No.
Lally, I mean, this is like, he's trying to show that they both ditched their phones. They both knew the conversations they had, the message they had, the timing of all this was highly relevant and probative to show that something hokey's going on. And for the prosecution to object to this, just absolutely, absolutely despicable.
You testified at the other hearing in June of 2022, quote, I don't recall saying that I was going to get rid of my personal phone to Brian Higgins. I may have said that, there's personal stuff on my personal phone. I don't recall saying that to him, but I don't know. We had multiple conversations about things, end quote. Remember testifying to that?
Yes.
So you're not ruling out the fact that you may have told Brian Higgins that you intended to get rid of your phone, correct?
No.
You're not ruling out the fact that Brian Higgins may have told you that he intended to get rid of his phone.
No, I don't remember him saying that to me.
Your testimony was, quote, I know there were conversations about the phones. I just can't say if he was going to get rid of his phone or not, end quote. You testified to that, didn't you?
Yeah, I have no idea what he was going to do.
I'm asking, are those your words? Did you testify to that under oath?
Yes, although I don't know the context of the time that they were asking that question.
June of 2020.
No, not the date of the hearing, but when they were asking if and when that conversation took place.
Does it really matter when it took place?
I think so, yes.
When you talked to Brian Higgins about getting rid of your phones, when do you think you had that conversation?
I don't think I talked to Brian Higgins about getting rid of my phones.
Well, you just said you can't rule out the fact that you had conversations with Brian Higgins about your phones and possibly getting rid of your phones. Right?
No, I don't think that's what I said.
You two discussed the fact that you both wanted to get rid of your phones.
I don't remember having that conversation with Brian Higgins at all.
Your testimony was, quote, I know there were conversations about the phone.
He says, I don't recall about that. Surely that's something you'd recall because you're worried about getting busted.
Sir, correct?
Correct that that's what you're reading?
So if you're having conversations with Brian Higgins about the phones, what the heck were you talking about?
I don't know the timing of when they asked when those conversations were.
Mr. Albert,
So
I'm leaving it open to you. I don't care when it was. I'm asking you, have you ever had a conversation with Brian Higgins about your phones, respectively?
we may have, I can't remember that conversation specifically.
Then why, in June of 2023, did you testify, I know there were conversations about the phones with Brian Higgins, end quote.
I'm not sure of the context of that.
So now you just can't remember.
No, I don't think I could remember during that testimony either. I think if you read the whole thing, I think I said I'm not sure. I don't remember.
Your quote was, I know there were conversations about the phones.
Why would they talk about the phones? Why were the phones so incriminating to them that they had to ditch them? That's what's really relevant here, and it's really revealing.
Just can't say if he said he was going to get rid of his phone or not, end
Right.
quote.
Right.
Does that help refresh your recollection?
Yes.
So now as you sit here and you answer my question, did you and Brian Higgins have a conversation about your phones?
I don't remember having that conversation with Brian Higgins.
That doesn't sound credible.
All right, let's shift gears. Before I shift gears, you're aware that Brian Higgins has also gotten rid of his phone, correct?
I am not aware of that until after the time you're talking about.
So without qualifying your answer my question. As you sit here, you're aware that Brian Higgins has also gotten rid of his phone.
I know at some point Brian Higgins,
Yes or no, Mr. Albert?
did he?
Objection, Your Honor.
Can you answer that, yes or no, sir?
Yes.
Okay.
Now I'd like to shift.
So, two law enforcement officers hanging out with John O'Keefe the night he died, and they ditched their phones close to around the time that they know that the phones are going to be seized and examined and forensically reviewed, and they just suddenly have to ditch these phones, right? So it's just very suspicious, and I think it shows that there's a lot more going on here that the state just does not want to open their eyes to.
Shift gears. I'm talking a little bit about Michael Proctor. Did Michael Proctor come into your home at 34 Fairview on January 29th?
Yes.
Michael Proctor? Let me rephrase the question. I want to make sure I'm not talking about Officer Lang, Officer Good.
Right.
Michael Proctor from the Massachusetts State Police. Did he come into your home on January 29th?
He conducted an interview with my wife, and I don't remember if it was the 29th or the 30th. That's what you're asking.
Wasn't that interview on February 3rd?
I feel like it was earlier than that, but it could have been February 3rd.
Okay. Presume for purposes of my question that it was February 3rd that Michael Proctor interviewed your wife. Then he would not have come into your home on the 29th, 30th, 31st, 1st, and 2nd.
Right.
And you know from your training, obviously, as a first responder, the first 48 hours of an investigation are absolutely critical, correct?
Objection.
Do you know that, sir?
Why wouldn't you just allow him to ask this question? Why is Lally objecting? It's a perfectly legitimate line of questioning. And so for the judge to then asking the officer on the stand to answer the question for her, she's just taken away the effectiveness of the defense counsel. And her being a long-term public defender doing this kind of stuff, it's just very much disturbing to see.
In that context, I don't.
Next question.
I mean, there's even a TV show called The First 48 Hours. if you don't solve a murder in the first 48 hours, there's a high chance you never will. So those first 48 hours, that's what he's alluding to, is very critical. And so for him to play dumb with this, it's just, and the prosecution objecting and trying to protect him and whatnot. So, one of the things I've seen before is I've had prosecutors that'll object, and they're basically, it's a way to telegraph to the witness, like, don't answer the question, play stupid with it. So I don't know if that's going on here, but I've seen that happen before. And so it's part and parcel for the kind of stuff you see when the truth doesn't want to be revealed, and the government has got stuff to hide.
I mean, you're aware there's a TV show called First 48.
Objection, Your Honor.
Do you think the first 48 hours of a criminal investigation are critical?
Objection.
You do know that the longer you wait to properly investigate anything, the better chance that evidence can be manipulated or destroyed, right? You would agree with that?
Yes.
Did an investigator or any forensics team ever come into your house, ever, to photograph your entire home?
No, I wish they had.
Did an investigator, yeah, me too.
Objection, Your Honor.
Nancy, 27, you're saying, in your opinion, which is worse, the way the investigation, quote unquote, was done, including Proctor looking for nudes of Karen Reed, or the way the trial was done? I would say probably the investigation was one of the most disturbing, non-conforming type of sham. It's not, I wouldn't even call it investigation, like you're saying, to put in quotes. I mean, it was like a complete hot mess disaster. And then you prop that up into court here with a guy like Lally that's just having an objection fest, trying to derail the defense from having a fair trial every step he can. The whole thing is just absolutely a disgrace. And so it's an embarrassment as an attorney to see this going on. So think about it, regardless of which side you're on for Karen Reed, whether you think she's guilty or not, seeing this kind of way that they're trying to just hijack the whole process, it's so lopsidedly unfair to an accused. Imagine if you're having yourself or a loved one in this kind of situation and you got this kind of racket going on. And imagine if you had a loved one that was murdered, and this is the kind of way the cops treated this whole case. This is the way they treated the accused. So it's just something that's so far out there, and a textbook case of how not to conduct an investigation, how not to prosecute a case. As I saw earlier, that the North Carolina patrol officer that's retired also said this is a textbook on the way this should not be done. So we were in agreement with that this is such a hot mess disaster that that alone is reasonable doubt. If you don't have the kind of evidence squared away for trials nowadays, keep in mind it's been drilled down through so many juries. Unless you have CSI, those crime shows type of evidence, you got the DNA type of stuff to solve the crime. Juries nowadays are very much different than they were before. They're sort of looking for this kind of CSI information. They're looking for the forensic kind of data to show who done it. Here you have none of that to help the prosecution. It actually helps the defense. So this is back to your question, Nancy, 27. This is it's from A to Z. This thing is a textbook case of justice gone wrong. It's not about justice. It's about going after somebody when you don't have your ducks in a row, and it looks like there's other folks that never got the proper scrutiny. To this day, as we see here, Brian Elbert's house was never searched for any kind of forensic type of value, and who knows what they could have found in there. They should have been searching that house with a fine-tooth comb, and maybe they would have seen some things in the house that would blow the whole case wide open. But he's a law enforcement officer, and the kind of deference they gave to him, they didn't give that kind of deference in fairness to John O'Keefe. So it's definitely looking like nothing but corruption from the get-go.
Did an investigator or a forensics team ever come into your house to search for physical evidence?
No.
Did an investigator or a forensics team ever come into your house to search for trace evidence?
No,
Did an investigator or forensics team ever come into your house to take carpet samples, flooring samples from the basement, for instance?
no,
And to this day, you're aware that that's never happened.
yes,
Sir, you were in the Marines before you were a police officer, correct?
yes,
You're a combat veteran?
yes.
How long were you in the Marine Corps?
4 years?
During the course of your Marine and military training, did you have any training in hand-to-hand combat?
Objection.
I'll allow it.
Okay, he's trying to ask him about hand-to-hand combat because he's looking at him as a suspect. That's something the defense should be doing, is making him out to look like he could have some culpability in this. That's what defense counsel have to do, is that they need to be able to create reasonable doubt. And one of the ways you do it is by making it look like, hey, other people's behaviors are highly suspicious. And so anything they did that looks suspicious, they got to bring it out. Anything about them that could also be an indicator that they had the capability of doing something like this. So him being a boxer, him having the weights in the weight room, basement there, all these kind of things, there are something that a defense counsel must do to effectively represent their client. What the problem is we have here is that the prosecution doesn't even understand what the defense is supposed to do under the Constitution, and doesn't understand the confrontation clause. So that's just so much a reoccurring theme in this trial, and I suspect it'll be the same thing going on in the trial coming up in April.
Yes,
In addition to your Marine training on the subject, did you also receive additional training from the police department through the academy or otherwise on basic hand-to-hand combat?
no.
So that's not part of the academy?
Not hand-to-hand combat, no.
Fighting techniques, use of batons, things of that nature?
Defensive tactics.
Defensive tactics. Okay, that's fighting, right?
Well, it's not hand-to-hand combat, no.
Okay, fair enough. I may be using the wrong word. It's physical, it's training on how to either defend yourself or control another person physically.
Yes,
I mean, they're not going to send you out there on the streets completely ill-equipped. They need to know that you know how to defend yourself and how to put somebody in custody that doesn't want to be in custody, correct?
yes.
And that might include fighting.
It could, yes.
And beyond your Marine training and your police training, you're independently trained in techniques of fighting.
Have I boxed before? Yes.
Okay. And you've trained in boxing. It's not like you just walk up and smack a heavy bag, right?
You'd have to rephrase it.
You've trained. You're a trained boxer. You're a trained fighter.
I've boxed in the past, and I've trained to box, yes.
Yeah. I mean, I've hit a heavy bag,
Right.
but I'm not a trained fighter. You're a trained fighter.
All right, so there's an objection. You were standing, Mr. Lally.
Yes, sir.
Jurors, disregard that. Mr. Jackson, no comments, just questions, please.
Yes, Your Honor. In fact, your boxing skills were featured in a TV show that you were featured in as well, correct?
Objection.
I'll allow that.
No.
You were, in fact, no.
That they were featured in a show? No.
You were never shown on TV in a ring sparring with somebody?
I may have been shown training, but I don't think I was having a boxing match. No.
Okay, I wasn't suggesting that you were having like a paper. I was asking, is there a TV show that ever showed you in a ring boxing?
Well, that's not what you asked me, but if you're asking me that now, yes.
I'm asking you that now. I apologize. My questions are somewhat inartful.
Yes.
You understand the question now?
Yes.
And you have been shown, I use the word featured, you've been shown on television in a boxing ring,
Yes.
sparring.
I haven't seen the video in a while. I'm not sure if I was sparring.
If we can, Your Honor, with the court's permission, can we take a look at Exhibit 53?
Okay.
To answer your question, Joan, you're asking which witness from this case are you most excited to cross-examine as an attorney? Wow, I'd probably say Proctor is, I mean, there's so many good ones. I guess I don't have a favorite. I would say Proctor, Trooper Paul, Detective Albert here. I mean, they're all golden witnesses to prosecute, and question in their contradictory statements, their incredible statements, their lack of memory, the bobbing and weaving going on. the lack of understanding of simple police procedures. And so there's so many reasonable doubts here through all these witnesses. So there's golden nuggets that you could easily completely shred these witnesses' testimony. So I think that they could have done a lot better job shredding the testimony of all these different witnesses. So that's maybe something we can talk about when I cover these other witnesses. Some of the different techniques and styles they can use to bring out different things. So I do like it when this attorney Jackson is getting more in his face, raising his voice, being more combative and aggressive in the questioning of him, because this witness needs to be challenged on so many things he said and done surrounding this case.
There's a clip starting at it's time of day 11:47 and 15 seconds to 11:48 and 35 seconds, maybe a minute and a half. Can you enhance that? So pause. Do you see the two men in the foreground?
Yes.
Who are those two men?
Looks like myself and Brian Higgins.
Does it look like yourself and Brian Higgins, or is that yourself and Brian Higgins?
Yes, it is.
Would you go ahead and play that? Sorry.
That's the kind of stuff I would say that tends to happen when folks are drinking a lot. So it looks like they probably had a lot to drink, and I don't recall that question being asked by the defense yet. Also, Gravel Gertie is saying, my husband graduated from UF College of Veterinary Medicine in 1988. He's a DVM, which is Doctor of Veterinary Medicine. When shown the John O'Keefe autopsy photos, empirically, he said canine wounds. So if you could just tell us where your husband's located, maybe he'd be willing to assist the defense. And also provide his name. That'd be helpful. Thank you.
I've got one more clip to play, but I have a couple of questions, Your Honor. Would you,
Let's take it down and you can put the other one up after the questions.
Did you see what was displayed on that video?
Yes.
Had you seen that before?
Part of it, yes.
Is that what you and Mr. Lally went over in your preparation for your testimony?
I don't think that we went over it, but he showed me a quick clip of it.
When you say he showed you a quick look, did he ask you questions about it?
I don't think so, no.
Did you give him any answers about it?
No,
Any explanations?
no, just,
He just showed you the clip and?
yeah, he just said, yeah, it looks like we were fooling around.
Okay, so you did make an explanation, you've given him an
Yeah,
explanation for it.
right, I said, I think we were just fooling around.
Okay, it's the same thing you told us this morning, right?
Right,
Just fooling around.
yeah, just having fun with my friends and hanging out and fooling around.
Absolutely. What were you doing? Describe what you were doing.
Having fun with my friends, hanging out, just being silly.
Okay. Describe physically what you were doing in the video.
I was playing around, sort of getting in a boxing stance.
Okay. Otherwise known as a fighting stance, correct?
Yeah, for a second, yes.
Okay. And what did Brian Higgins do when you got into a fighting stance?
It looked like he was kind of doing the same thing. We
Got
just,
fighting stance as well, correct?
yeah,
What were you two talking about? You tell you talking.
yeah, I don't know what we were talking about. We were just being silly, fooling around, having fun.
Were you giving him advice on the proper way to get into a fighting stance or a boxing stance?
No,
You giving him some advice or some indicators about how to best position himself if someone is taking an aggressive stance against him?
no.
Is he telling you what he thought was a good technique for fighting or boxing?
I don't think it was that serious. We were just playing, fooling around.
But both of you were in fighting stances facing off against each other, correct?
Yeah, for a second or two.
And Mr. Higgins, you saw him bob his head and then start walking toward you like a boxer might, correct?
Yeah, yes.
And then you got down, pulled your the pant legs up, and you squatted down to indicate getting low, having low center of gravity, correct?
That would know that's indicating being silly.
Okay. And
That's
then at
not.
some point, while you're being silly, you then faked a right punch toward him, correct?
I didn't notice that, but I'm not sure.
Can we take a look at the next part of this clip, which is at time of day 11:55 and 51 seconds. I'm sorry, 11:54 and 52 seconds. So pause. Do you see the two men in the foreground?
Yes,
Who are those two men?
looks like myself and Brian Higgins.
Does it look like yourself and Brian Higgins, or is that yourself and Brian Higgins?
Yes, it is.
Would you go ahead and play that? Sorry.
It's that way. Yeah, my understanding is the O'Keefes are all behind the notion that Karen Reed is the proper target of the prosecution, and why they don't have these serious questions that we're raising here, discussing evidence critically and with an open mind, and raising all these disturbing questions about due process is it's hard to understand. But that's typical. What I've seen is the families will side with the prosecution. They don't want to believe the prosecution is not going to do the right thing, so they stay locked and loaded, and they don't move off that dial, no matter how much common sense and evidence flies contrary to what the prosecution's telling them.
I've got one more clip to play, but I have a couple of questions, Your Honor. Would you,
Let's take it down and you can put the other one up after the questions.
Did you see what was displayed on that video?
Yes,
Had you seen that before?
part of it, yes.
Is that what you and Mr. Lally went over in your preparation for your testimony?
I don't think that we went over it, but he showed me a quick clip of it.
When you say he showed you a quick look, did he ask you questions about it?
I don't think so, no.
Did you give him any answers about it?
No,
Any explanations?
no, just,
He showed you the clip and?
yeah, he just said, yeah, it looks like we were fooling around.
Okay, so you did make an explanation, you've given him an
Yeah,
explanation for it.
right, I said, I think we were just fooling around.
Okay, it's the same thing you told us this morning, right?
Right,
Just fooling around.
yeah, just having fun with my friends and hanging out and fooling around.
Absolutely. What were you doing? Describe what you were doing.
Having fun with my friends, hanging out, just being silly.
Okay. Describe physically what you were doing in the video.
I was playing around, sort of getting in a boxing stance.
Otherwise known as a fighting stance, correct?
Yeah, for a second, yes.
Okay. And what did Brian Higgins do? You got into a fighting stance.
It looked like he was kind of doing the same thing. We
Got into a
just,
fighting stance as well, correct?
yeah,
What were you two talking about? You tell you talking.
yeah. I don't know what we were talking about. We were just being silly, fooling around, having fun.
Were you giving him advice on the proper way to get into a fighting stance or a boxing stance?
No.
You know, for them to be horsing around like that, it shows that they have a lot of connections. Keep in mind, he's known him for 15 years. So they are very good friends. They're very tight. And of course, they're going to be talking about stuff about the phones, how to ditch the phones. They're going to be talking about a lot of stuff. And because they're intricately involved in what happened and went down that night.
No.
You giving him some advice or some indicators about how to best position himself if someone is taking an aggressive stance against him?
No.
Is he telling you what he thought was a good technique for fighting or boxing?
I don't think it was that serious. We were just playing, fooling around.
But both of you were in fighting stances facing off against each other, correct?
Yeah, for a second or two.
And Mr. Higgins, you saw him bob his head and then start walking toward you like a boxer might, correct?
Yeah. Yes.
And then you got down, pulled your pant legs up, and you squatted down to indicate getting low, having low center of gravity, correct?
That would know that's indicating being silly.
Okay. And
That's
then at
not.
some point while you're being silly, you then faked a right punch toward him, correct?
I didn't notice that, but I'm not sure.
Can we take a look at the next part of this clip, which is at time of day 11:55 and 51 seconds. I'm sorry, 11:54 and 52 seconds. Pause it. And highlight it. Okay, there's several individuals crowded around a table. Can you describe where you are and where Mr. Higgins is?
Brian Higgins is the guy on the right with the hooded sweatshirt and the emblem on the back. I have a pointer. Do you want me to use it?
That'd be great. That'd be great.
So that's Brian Higgins, and that's me.
Okay, go ahead and play this. Pause. You see what you just did?
Yes.
What did you do when you slapped his right arm?
What did I do?
What did you do? What are you doing?
It looks like I'm just being silly, fooling around.
Okay, I'm going to ask you for a little bit more physical description. What are you doing? Why are you grabbing him from behind?
I don't really know.
Is that a wrestling hold?
No,
Is
I
that a
don't think.
control hold?
No, I don't think so.
Is that some sort of a control hold that you've used in the past?
Bear hugging somebody? No. That's
Okay,
just a silly fooling around with my buddy.
let's go ahead and play this.
I think it shows again that they've been somewhat over drinking that night, and they were going to be driving again because that seems to be sort of something that was commonly done. And so, yeah, it's helpful here to show that these guys are just not acting like normal adults of their age, having responsible drinking. It looks like they had too much to drink while this horseplay going on. You got a point here by the trooper officer retired from North Carolina. Yes, it is defensive tactics in hand-to-hand combat. So to try to parse those words again, of course, you want to know how to defend yourself when you don't have a weapon. If your gun doesn't fire, you want to be able to go hand-to-hand against criminals you're trying to apprehend.
Stop it.
Look
You
at
see what
that
Mr. Higgins just
knee kick even. See that knee kick to the chest? I mean, it wasn't a real kick, but they're definitely Definitely almost acting like young teenagers goofing around here.
Did?
I did, yeah.
When you let him go, what did he do?
I don't know. He did some kind of, I don't know, he pretended to knee me or something.
Knee to the abdomen?
Yeah, I don't know if it made contact or not, but
Mr. Albert, I'm not suggesting by my questions that you two are actually in a fight.
right.
I'm asking what he's doing. Does it seem to
Yeah, I don't,
you that he's playing like or practicing like techniques in fighting?
I don't know what his intent was. It looks like he's just fooling around just like I was.
But if a grown man walks up to you, grabs you from behind, and puts a knee up to your solar plexus, that's probably not the same as a high five, right?
What is your question?
In other words, it looks like he's practicing some sort of fighting technique.
Practicing? That's not how I see that.
How would you describe it?
I would just describe it as him fooling around. We're in the bar together. We're good friends and we're just being silly and fooling. That's all.
There's a number of people in that bar. You would agree with that?
Yes.
You see anybody else in that video at any time getting physical with one another?
Objection.
How much of this video have you actually watched?
Not much.
Okay, then let me ask a different question. From your memory of that night, who are the only two people in the bar that seem to be getting physical with one another?
Objection.
Can you answer that?
Sure. The only person I remember being physical with.
Why can't you just say overruled? How often have you ever heard her say overruled when the prosecutor makes an objection? I don't think I've ever seen it, right? That's something that a judge normally makes. They either say sustained or overruled. And instead of saying overruled, she doesn't want to look like she's against the prosecution, like they may be overstepping their bounds on the objection. So what does she say instead? She says something directly to the witness, again, looking like she's on the side of the prosecution and trying to cut the momentum from the defense off of the knees.
Was fooling around with Brian.
Okay, but just a little bit longer. Almost finished.
I'm planning on going over some more as well. So yes.
Let me take that down. Did you see the rest of that video?
Yes.
No question that you two are being friendly with one another, correct?
Yes.
You would agree with that?
Yes.
But there's also no question that of all the people in that bar, the only two people that appear to be imitating fighting are you and Mr. Higgins, correct?
In that video, yes.
And is there another video? Do
Well, no, I just don't know what everybody else was doing in the bar.
you remember anybody else? You know, Julie Albert or
I don't remember.
Nicole getting into a scrap with someone?
No.
That's just you two, correct?
Yes.
Mr. Albert, this is minutes before everybody headed to your house at 34 Fairview, correct?
Yes.
Including John O'Keefe.
Yes.
Going back to the morning of January 29th, everyone had left your location. This is after you had already arrived, had a couple of beers, people started leaving. Everybody was gone from your location
All right.
at about 1:45 a.m., maybe a little thereafter.
That seems right.
Caitlin being the last person to leave.
I believe so, yes.
What did you do to get ready for bed, to settle in?
I went upstairs and just lied in bed. The TV was on. I was just kind of watching TV.
You have a nightstand?
I do.
Is it on your side of the bed or Nicole's, or you have one on each?
We may have had one on each in that house.
Put your phone on your nightstand?
No.
Where'd you put your phone?
The phone was in bed with me.
So your testimony is that you get in bed after being on a road trip all day long, then at restaurants, and at bars, then at a get-together
Yeah.
at your house, and when you go to bed, you don't charge your phone?
No, I had the phone in the bed with me.
Why would you have the phone in bed?
We have 5 kids, and if somebody was trying to call or if I needed to reach them, it's just kind of a habit I do. I put my reading glasses and my phone in bed with me.
And you don't charge it.
Sometimes I charge it, but not as a routine, no.
So you're worried about having your kids out. They might need to get a hold of dad. So you make sure that your phone is nice and close, but it can just run out of batteries.
Well, if it's dying, then I'll put it in the charger. But if not, I just leave it on the bed.
Well, what about that night?
That night, the phone was on the bed.
How do you know?
Well, I remember the phone being on the bed.
You have a specific recollection from 2.5 years ago about the state of the battery charge on your phone such that you know it was in your bed that night.
No, I just know as a routine, I keep my phone on the bed with me.
That's not what you just said. You just said,
Yeah, going back to destroying the phones, I mean, this is something, as the defense counsel, I would have just jumped all over this witness on. I would just make this out to be such a huge deal. And so Jackson's, probing away at this, exposing different things like that, but he never makes this look like such an outrageous action from this police officer. The righteous indignation is not coming across, I think, strong enough by Jackson on this kind of stuff. And the way to sort of cross-examine them is also maybe to belittle them at times, and just sort of like ask questions like, you seriously expect, and then ask the line of questions about how ridiculous what their storyline is. So there's many ways to go about it and going after them. And I just wish he was more aggressive on it and acted more outrage, like the moral outrage of how this was not following, none of this was following police procedure. So I think part of it is maybe the jury didn't understand how bad and botched this was for a lack of investigation. So that's something I would recommend they do differently next go around. Is you gotta hammer these witnesses harder. You gotta make it where they know that you're all over them about how bad they botched his case. So I just don't see that from Jackson here. He's got a good voice control. He is asking good questions, but he's not going after the jugular enough, and he's not showing the outrage of how ludicrous a lot of this testimony is.
it depends on whether or not the battery needs to be charged, whether or not you charge it.
My answer is that sometimes I, of course, charge my battery,
Of course you have.
but I sleep with the phone in my bed.
Every single night?
Yes, mostly every night.
I thought you just said 4 questions ago, it depends on whether or not the phone needs to be charged. Sometimes you keep it in bed, sometimes you put it on the charger.
If the phone needs to be charged, I charge it, but I sleep in bed with my phone.
Mr. Albert, did your phone need to be charged that night?
I don't remember if it did, but I slept in bed with the phone.
You've been on a road trip most of the day, correct?
Yes.
You've been out at bars that night, correct?
Mm-hmm.
Is that yes?
Yes.
You weren't charging your phone. We saw the video. You weren't charging your phone at the bar.
Right.
So when you got home, clearly put your phone on a charger, didn't you?
But I did not.
So if your kids needed to get a hold of you, why would the phone being in your bed be any assistance to you instead of just on the charger at the nightstand?
That's just what I've always done. I just keep it in my bed. My wife does the same thing.
Okay. So now you've got 2 phones in the bed.
Yes.
Okay. And your glasses.
Yes.
Right between the 2 of you.
Yes.
Got it. Your phone have a ringer on it?
It does.
Ever thought about maybe turning the ringer on just in case the kids need to get a hold of you?
Sometimes it's on vibrate. Sometimes it's on ring. It depends.
Yeah, it depends on you. You just put it on ringer. Wouldn't that make more sense to go to bed and put it on ringer?
Objection.
Can you answer that?
All I can answer is that I sleep with my phone in my bed.
Again, why is the judge directly going to the witness? Doesn't want to go against the prosecution. And what I've heard is that Morrissey, the district attorney there, was the one that actually helped get this judge her judgeship. So if that's the case, if he was, I guess he was a former state senator, so he's very influential in the party politics there. So if he's the one that was really behind the judge getting this job as a judge, then is there some kind of favoritism going on for that reason?
Bad. That's just what I do.
And you know what I'm about to ask you, which is why you're saying you sleep with the phone in the bed, correct?
All right,
I
so
s-
that's sustained, that's stricken. Or Mr. Jackson.
All right. What else is in the bed with you? Your keys, your wallet, any other pocket items?
No.
Just the phone and your glasses?
Yes.
And Nicole's phone,
Yes.
right between the two of you?
Usually, yes.
What about that night?
Yes.
Sir, did you make any phone calls after you went to bed between the hours of 1:45 a.m. and 6:30 a.m.?
Yes.
Who did you call?
I inadvertently called Brian Higgins.
What time?
I don't recall the exact time. After 2.
2:22 and 35 seconds. Does that sound familiar?
Yes.
Did you speak to Brian Higgins at any point between 1:45 a.m. and 6:30 a.m. that night?
No.
You say you inadvertently called him at 2:22 in the morning.
Yes.
How did you inadvertently call him?
Well, I don't know because it was inadvertent.
So I have to explain that.
Well, it's kind of like a butt dial.
I don't like the butt that. All right. How long have you used an iPhone?
A long time.
As a matter of fact, you've been asked this question before, haven't you?
Yes.
Hence my question. You knew what I was going to ask you.
Objection, Your Honor.
I'll withdraw. You indicated previously at a different hearing in June of 2023 that you were, quote, hanging out with your wife and you must have butt dialed Mr. Higgins, correct?
Yes.
At 2:22 and 35 seconds on January 29th, 2022, correct?
Yes.
You were asked how that could have happened, much like I just asked how that could have happened, right?
Yes.
And in that hearing, you said, quote, I'm not totally sure. Similar to what you just said here.
Yes.
And here you added that it could have been a butt dial.
Yes.
You were then called back to that same hearing, but at a different date, an ongoing hearing, right?
Yes.
That was in July of 2023, correct?
Yes.
You then changed your testimony and said, and I don't mean to be indelicate, but your testimony was then that you were in an intimate situation, I'll put it that way, with Nicole at the time. And that's how you butt dialed Brian Higgins, correct?
I don't believe I said that's how I butt dialed Brian Higgins.
That's the time.
I think I said there was a time frame that was close.
Okay.
So I didn't say that, no.
All right. What you said was you were in an intimate situation with Nicole at the time that the butt dial occurred, correct?
I'm not sure if you have something you can read me or show me.
Is it your testimony, let me just ask, is it
Sure.
your testimony that you and your wife were in the middle of some sort of sexual or intimate situation, and that's what caused you to butt dial the phone at that time at 2:22 a.m.?
Objection.
Sister.
I want to show you an exhibit briefly. Oh, sorry.
Is that true? Lori's saying that Brian never went to John's funeral, but drove to New York for another cop that he didn't know. And so that's New York City, not just New York City, but all the way down to New York City. So I'm not tracking whether he went to the funeral or not, but does anyone have the answer to that? If you do, please go ahead and jump in.
Yes.
That's really shocking if that's true.
May I approach people?
Yes.
I'm not gonna mark this decision. Sir, I just want to find out if this refreshes your recollection. Look at lines 11 through 13, and then let me know when you're prepared.
Yes.
Thank you. May I approach?
Yes.
Does that refresh your recollection that you indicated at the other hearing that,
Just the first part of that first. Does that refresh your recollection?
It does.
Okay, now you can.
thank you, Your Honor. Isn't it true that at the other hearing, you indicated that at or around the 2:22 timeframe, you and your wife were in bed together in an intimate situation?
Yes, around that time, I think it reads.
May I approach briefly, Your Honor?
Yes.
Well, with the court's permission, let me ask a couple of questions. Do you recall every call that you made between, say, 1:45 a.m. and the next couple of days? You remember every single one of those calls?
No.
Do you think it would refresh your recollection to look at a log of those calls during that time frame if we're going to discuss those?
Yes.
May I approach, Your Honor?
Yes.
Yeah, a butt dial at that time in the morning sounds very suspicious. And also keep in mind, so that was at 2:22 in the morning, and this 5 minutes later is when the Google search for Jen McCabe about how long does it take to die in the cold. I understand there's some discrepancy that there maybe it was later in the morning, but that was erased. So I believe it was the 2:27 Google search. Yeah.
I may not even get it. But I'll show it to you. Okay.
Mhm.
Recollection as we walk through. Now, Your Honor?
Yes.
That's 2 pages worth of documents. If it refreshes your recollection as we walk through this, with the court's permission, let me know if you need to refer to that.
Right. I'm not going to be able to read it right now. I'll do it as you ask.
Correct, yeah. No, you don't need to read it right now. Just wanted to have it in front of you. By the way, you've seen these records before, correct? At the other hearing proceeding?
I've seen some records before, yes. I don't know if these exact records or not.
All right, and you've acknowledged that at least the first page, these are your phone records for the number ending 0888, correct?
Yes.
Okay. And these are call records from January 29th
Yes.
at 2:22 and 35 seconds in the morning, correct?
Yes.
Whose number ends in 5421?
According to this, it's Brian Higgins.
The call at 2:22 and 35 seconds appears to be 1 second in length, and that's from you to him, correct?
It says 1 second.
That would be the call, the initial call from you to him, the one that you claim is a butt dial. Is that right?
Yes.
Did that call roll to voicemail and then you immediately hung up?
No, I don't recall if it, I don't know.
So according to you, it was a butt dial that went to his phone and somehow lasted 1 second.
Right.
Okay. Then there's a second call. If you look at the second line down, there's a second call at 2:22 and 52 seconds, 17 seconds later, correct?
Yes,
That call is actually from Brian Higgins to you, isn't it?
yes,
And that call doesn't last 1 second. That call lasts 22 seconds, correct?
yes.
Obviously, you know how long 22 seconds is.
What's that?
You know how long 22 seconds lasts.
Yes.
Yeah, I don't know anything about the arms in a sling a few days after the death of John O'Keefe. So not sure where you got the information. If anybody else can add to that, please.
So according to your phone records, you placed a call to him, and then 17 seconds later, he returned a call to you that lasted 22 seconds, correct?
That's what the records reflect, yes.
When you woke up in the morning, you obviously checked your phone, did you not?
I don't know if I did.
Are you telling this jury that the call that came into your phone was a missed call, or did you answer it?
I did not answer it.
So it would have been a missed call.
I just know I didn't answer the call.
So it would have been a missed call.
Well, I don't know. I don't know that to be a fact. I just know I didn't answer the phone call.
Okay.
I missed the call. Yes.
That's what I mean.
Right.
You missed the call.
Right.
It did something on your phone and you just didn't answer it. What do you?
Right.
Okay. And again, you're using an iPhone.
Yes.
If you butt dialed Brian Higgins and he called you back and you didn't answer, you would have a very bright red missed call in your call log, correct?
Objection.
Do you know that?
I don't know that.
Oops, something's going on here. Sorry, it keeps going back. Stuck on reverse. Sorry. Something's acting up. Well, we're here at the 2-hour mark, so I'm going to go ahead and continue this for a part 3, and we will discuss in more detail what's going on with this sergeant detective from the Boston Police Department. And keep in mind, this is the gentleman who had John O'Keefe die in his front yard. They're saying it was a second-degree murder by Karen Reed, and yet his house was never searched. He does all this suspicious stuff, ditching his phone. He never has the other things that were going on, like the dog barking or waking them up, causing a commotion to go out and see what's going on with John O'Keefe's body laying there in the snow. So something is very amiss here. This doesn't add up. And I know there's some stuff that we've heard from a juror or two on how their deliberations went. But keep in mind, even with this railroad job of a type of prosecution, and even with this kind of testimony from this Brian Albert, there is still so much there that that was lacking, that they couldn't even prove murder in the second against Karen Reed in the first trial. So the second trial, I think, is going to be so much better for the defense. Normally, the second go-rounds of those hung juries more helpful for the prosecution than defense. But the bottom line is, I don't think there's going to be any scientific forensic type of evidence that's going to be able to assist the second jury to find anything showing that this is a credible story, that we saw Trooper Paul make out that John O'Keefe did some kind of a helicopter spiral after he got hit with his arm, goes 10 feet up in the air and 30 feet away from the point of impact. That is this really just this wild speculation that defies physics. Okay, that's what it is. And so really it comes down to the state has a burden of proof, which is beyond a reasonable doubt. And to be able to prove that, they have to remove any doubts of what really happened. They have to be able to pin it on the defendant, in this case, Karen Reed. But what they don't have is any plausible, believable story of how it really happened. I mean, no one can say for sure how John O'Keefe died. We really don't know. And if we really don't know, that right there is reasonable doubt. If the physics doesn't line up with the government's theory, that right there is reasonable doubt. So no matter how you slice it and dice it, no matter whether you think Karen Reed's guilty or not, here in America, we go by proof beyond a reasonable doubt. We don't go by hunches. We don't go by feelings. We don't go by beliefs. You can know in your heart somebody did it, but if there's really not evidence there, solid evidence that you can rely on and hang your hat on and say, you know what, this is credible, it's believable, it's backed by common sense, it's backed by science. All these kind of things have to support a conviction. So here, you won't even have, even if they would get a conviction from a second jury go around, I don't think you're going to see any kind of conviction that's upheld by any kind of appellate review, unless the corruption extends up to the Supreme Court that bad that they want to do this kind of cover up. I just don't think that this thing's ever going to pan out for a conviction for Karen Reed. I think they're ultimately going to fall flat on their face. I think all these lies are going to be even more held accountable in the second trial. I think the kind of lies we're seeing here that you guys are picking up on, that all this bobbing and weaving going on, is just not. He's not going to pose as a credible witness. All these other witnesses that they propped up, even though I know that there's a juror that said all these were just a distractions to the ultimate issue, which is Karen must have hit him, or that was what they really were discussing. The bottom line is that they have to have proof of how this happened. None of these witnesses are credible, and they all leave you scratching your head thinking, what really happened inside and outside that house? Why would there have to be a text message saying, of course, John didn't come into the house? Words to that effect. They don't want to have John in the house because that makes the inside of the house subject to a search warrant, the inside of the house subject to all the CSA type of examination. All these folks have been hauled down to the police station and interviewed. But because it was a police officer's house it happened in, nothing was treated by the book. It was all just treated as if this is just nothing but a little misdemeanor case. Heck, a dog bite case would probably get better investigation than this. So it's completely botched. And so we'll come back to this. It's getting late here, so we'll come back. I'm thinking we'll likely do this again on Friday night. So look back Friday night. If I'll do an announcement, I'll try to give more advance notice, but I'm thinking maybe next Friday night is when we'll have the final version 3 of this, part 3 of this review, and then we'll jump on to other witnesses as well. If you guys want to tell me which ones you'd like to see the most, I've seen some folks saying Jen McCabe should be next. Maybe Proctor. You tell me who you think should be the next one we review here, and we'll go from there. So with that, I'm going to go ahead and sign off, and you all have a great week. Be safe, and we'll see you here in a few days.